Regulations of the hearing. In order to ensure the public order, security and the effective functioning of the proceedings, during the hearing on the 3rd of April 2009, the President of the Pretrial Chamber has established the following regulations. 1. All persons who wish to attend the hearing shall appear on the premises of the extraordinary chambers in the courts of Cambodia before 9 a.m. on the date of the hearing. 2. All cameras, camcorders, tape recorders, and loudspeakers are prohibited inside the courtroom, except as otherwise ordered by the pretrial chamber. 3. All persons are prohibited from smoking, bringing food or drink inside the courtroom. 4. All weapons are prohibited inside the courtroom. 5. Cell phones may not be used inside the courtroom. This includes the use of cell phone cameras and audio recording by the cell phone, which is strongly prohibited. 6. Moving, changing seats, or walking freely inside the courtroom without permission is not acceptable and strongly prohibited. 7. All persons are prohibited from shouting or making loud sounds inside the courtroom. 8. All persons shall communicate with the security staff of the ECCC if they need to enter or exit during the course of the hearing. 9. Persons under the age of 18 are not permitted to enter the courtroom. The President of the Pretrial Chamber may take direct action against those persons who breach these regulations or commit any illegal activity against the proceedings as a result of the actual acts or offences committed. The co-prosecutors arrive. Four members of the media representatives are invited to come to the courtroom. Say the graphic. Please be seated, says the President. The President, I now invite the media representatives to leave the courtroom. In the name of the Cambodian people and the United Nations, today the pre-trial chamber of the extraordinary chambers in the courts of Cambodia declares open the hearing of the TUC number 002-1909 2007 ECCC OCIJ in brackets PTC 14 dated 28th October 2008 and criminal case file number 002-1909 2007 ECCC OCIJ in brackets PTC 15 dated 18th of November 2008, in which the charged person Kieu Samphan alias Haim, Cambodian nationality, male, born on the 27th of July 1931 in Rumchek Commune, Rumdul District, Svai Rieng Province, Cambodia. Pre-arrest address: Kon Klong Village, Otawao Quarter, Pailen District, Pailen Town, Cambodia. Father's name Kieu Long, deceased. Mother's name Bao Kong, deceased. Is charged with crimes against humanity and grave breaches of the Geneva Conventions of the 12th of August 1949. Being crimes set out and punishable under Articles 5, 6, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia, dated 27th of October 2004. Defense co-lawyers: Mr. Saw Sowan, Mr. Jacques Wedges. Lawyers for the civil parties: Mr. Hong Kum Soon, Mr. Lau Chun Thi, Mr. Ni Chandi, Mr. Kung Pisay, Mr. Yong Panat, Mr. Kum Meng Ki, Ms. Moch Sawanari, Ms. Silke Studzinski, Ms. Martin Jagang, Mr. Philip Cannon, Mr. Pierre Olivier Schur, Ms. Elizabeth Rasbesan Ratana, Mr. Olivier Bahoun, Mr. David Blackman. The greffiers are all the participants present at the hearing. The greffier. All the participants are present except eight civil party lawyers are absent. Only 6 of them are present today. Thank you. Today's hearing comprise of the composition of today's hearing include 1. Mr. Prakam San, President, Mr. Rowan Downing, Judge, Mr. Natal, Judge, 4. Mrs. Katinka Lahus, Judge, and 5. Mr. Huatwati, Judge. Mr. Pan Pixley, reserved Judge. Greffiers include Ms. Saw Chandrat, Ms. Anne Mary Burns. Co-prosecutors: Mr. Ye Chariya, Deputy Co-prosecutor, Mr. Vincent Deval Desmail, the Deputy Co-prosecutor. The charged person, Mr. Kieu Samphan, please stand up. What is your name? Have you got any alias name? I am also called Ham. How old are you? Says the president. What is your nationality? Says the president. The interpreter regrets that Kieu Samphan's mic is not actively activated. What is your occupation? I have no job, says Kieu Samphan. What was your occupation before being arrested, said the president. Before I was arrested, I did not have any job, says Kieu Samphan. I lived on farming. President, where did you live before you were arrested? I lived in Kon Klong, Ottawa, says Kieu Samphan. What is your father's name? Says the president. What is your mother's name? Said the president. And what is your wife's name? How many children have you got? Said the president. Kieu Samphan said he has 4 children. Have you chosen lawyers to defend your case? Says the president. Mr. Kieu Samphan said that he has chosen both national and international lawyers to help defend him. Pursuant to Rule 21(1)(d), said the president, of the internal rules, you are presumed innocent as long as your guilt has not been established. You have the right to be informed of any charges brought against you. You have the right to be defended by a lawyer of your choice, and you have the right to remain silent. Criminal case number 1, number 002-1909-2007, ECCC OCIJ, appeal against the co-investigating judge's order refusing the request for release. Mr. Hoodwati, you read the report out. Pretrial Chamber Criminal Case File number 002-1909-2007 ECCC PTC 14. The report of examination proceedings. Number 2, examination of the case by the co-rapporteurs. 1, the proceedings. A, introduction. Pursuant to Rule 7710 of the internal rules of the extraordinary chambers in the courts of Cambodia, the president of the pretrial chamber has assigned judges Hoodwati and Rowan Downing to set out the details of the order refusing request for release issued on the 28th of October 2008, against which the present appeal is lodged, and of the relevant facts. The president of the pretrial chamber has assigned both judges to work on the relevant facts of the case file number 002-1909-2007 ECCC OCIJ PTC 14 in brackets. Identification of the charged person. Kieu Samphan, alias Ham, male, born on the 27th July 1931 at Rumche Commune, Rumdul District, Svai Rieng Province, Cambodia. Pre-arrest address, village of Kon Klong, Sankat Ottawa, Khan Pailan City, father's name Kieu Long, deceased. Mother's name Pao Kong, deceased. Spouse name Sausajit with 4 children. Kieu Samphan is presented by co-lawyers Mr. Saw Sowan and Mr. Jacques Verges. Charges. Kieu Samphan is under investigation for crimes against humanity, murder, extermination, imprisonment, persecution, and other inhumane acts, and grave breaches of the Geneva Conventions of the 12th of August 1949. Willful killing, willfully causing great suffering or serious injury to body or health, willful deprivation of rights to a fair trial of a prisoner of war or civilian, unlawful deportation or transfer of unlawful confinement of a civilian, being crimes set out and punishable under Articles 5, 6, 29 new and 39 new of the law on the establishment of the extraordinary chambers in the courts of Cambodia dated 27th of October 2004. Purpose of this report. This report of the co-rapporteur set out the details of the decision appealed against the facts at issue before this court. It is to assist those who are not parties to the proceedings understand the matters before the court. B. Co-investigating judges order refusing request for release. On the 28th of October 2008, the co-investigating judges dismissed the application for release filed by Kieu Samphan's co-lawyers. Recalling their provisional detention order of 19th November 2007, the co-investigating judges held that there continue to exist well-founded reasons to believe that Kieu Samphan instigated the commission of crimes charged against him or aided and abetted in the preparation the perpetration of these crimes, thus concluding that the criterion of Internal Rules 63(3)(a) is met. The co-investigating judges also held that 4 of the grounds for provisional detention set out in Rule 63(3)(b) continue to be satisfied. They held that continued detention was necessary to prevent pressure on witnesses and victims as well as to preserve evidence. As the passage of time since the provisional detention of the charged person has not eliminated the risk, which is even more acute. In addition, the co-investigating judges held that Kieu Samphan's continued detention was necessary to preserve public order, as it is not excessive considering the gravity of the crimes charged against the charged person. To conclude that a decision to grant release within the fragile context of today's Cambodia could provoke protests of indignation which could lead to violence. The co-investigating judges also noted risk to the security of the charged person, considering the gravity of the crimes and the threat to public order if the charged person was released. The co-investigating judges further rejected the co-lawyer's request for bail as an alternate measure to provisional detention. They found that since a majority of the conditions of Internal Rule 63(3)(b) continue to be met, there is a strong indication that no other form of detention can outweigh the necessity for continued provisional detention. They also considered that detention for nearly 12 months is not excessive in the view of the scope of the investigations, the complexity and gravity of the crimes of which the co-investigating judges are seized. They have collected a large number, or rather a large body of evidence, notably regarding Kieu Samphan's potential role. Finally, the co-investigating judges held that the age and state of health of the charged person were not a bar to discontinued detention. In particular, they noted that age in itself is not an obstacle to detention, and that as of now, having examined all the elements, Kieu Samphan's state of health is compatible with his continued detention. C. Kieu Samphan's appeal. On 27 November 2008, Kieu Samphan's lawyers filed an appeal in which they requested that the pretrial chamber 1. Vacate the co-investigating judge's order refusing release, and 2. Order the release of Kieu Samphan. They do so on the main ground that the order is not justified having regard to the overall circumstances of the case and the fact that it is based only on the gravity of the crimes charged. D. Co-prosecutor's response. On the 28th of January 2009, the co-prosecutors filed their response, requesting the pretrial chamber to dismiss the appeal on the primary ground that the co-lawyers have not established a change in circumstances, or rather in circumstance since the initial provisional detention, and that the criteria contained in Rule 63.3 continue to be met. E. Response of the civil parties. The co-lawyers of the civil parties did not file any responses. 2. Examination by the co-rapporteurs. A. Failure to consider the overall circumstances of the case. First, the co-lawyers for the charged person argue that the order refusing release is not justified because it failed to take into account the overall circumstances of the case. Specifically, the co-lawyers point out that the co-investigating judges did not take note of the procedural defects and serious violations of the rights of the defense, including a long delay connected with the hearing on the appeal against provisional detention and the lack of translation of the case file. The lawyers contend that the translation issue in particular raises various serious concerns about the lawfulness and legitimacy of the proceedings against Kieu Samphan. Second, the co-lawyers argue that the co-investigating judges committed an error of law and relying on the gravity of the crimes charged to be in itself a relevant factor in refusing to grant the release of Kieu Samphan or considering alternatives to provisional detention such as bail. They submit that insofar as the charged person is actually presumed to be innocent, the judges must undertake an in concreto assessment of the real risks involved in granting release in order to satisfy the legal requirements. The co-prosecutors respond that the order is sufficiently and adequately reasoned, as the co-investigating judges are only required to set out the legal grounds and facts taken into account before coming to a decision, and are not obliged to indicate a view on all the factors, but only the relevant ones. They contend that the issue of translation rights and obligations pending before the pretrial chamber is not directly linked to the legality of provisional detention. The co-prosecutors further submit that the co-investigating judges acted in accordance with the international jurisprudence by considering the nature of the crimes charged as a criterion in the test for determining the reasonableness of provisional detention. They assert that the co-lawyers have erroneously claimed that the co-investigating judges failed to consider alternative measures to provisional detention solely on the basis of the gravity of the charges. B. Well-founded reasons to believe that the charged person may have committed the crime or crimes specified in the introductory submission, Internal Rule 63.3a. The co-lawyers point out that it was impermissible for the co-investigating judges to rely on well-founded reasons to believe that the charged person committed the alleged crimes in denying release, because the defense cannot mount a proper defense to refute this finding. They recall that the international co-lawyer is unable to examine the case file in a language which he understands. In response, the co-prosecutors submit that the co-lawyers do not seriously challenge the existence of a well-founded reason to believe that the charged person may have committed the crimes specified in the introductory submission. They add that the case file today contains evidence capable of satisfying an objective observer at this stage of the investigation that the charged person may have committed the crimes for which he is currently under investigation. C. Consideration of the grounds making provisional detention a necessary measure, Internal Rule 63.3b. The co-lawyers also submit that the criteria contained in Internal Rule 63.3b has not been met. They argue that the co-investigating judges have not established any of the conditions to justify Kieu Samphan's detention, and their decision is based solely on the gravity of the alleged crimes. First, they assert that the co-investigating judges have failed to show evidence of past actions or behavior by Kieu Samphan that demonstrates a concrete risk that he might exert pressure on witnesses and victims. Second, the co-lawyers submit that there is no factual evidence of a risk to public order as to show that release would actually disrupt public order.